I handled a motion for new trial yesterday in a really serious case involving charges that involve the potential for several decades, to be exact, 6 decades, possible prison sentence. And in the course of that hearing, the other lawyer who previously had represented my client, I called him as a witness and I talked to him about how it was that he handled plea negotiations on behalf of my client, whether or not he had good, clear communications with the client about what the plea offers were and what the possible sentence could be after a trial. It became really clear in the course of talking with him prior to the hearing and him testifying at the motion for new trial hearing that he really had no idea how to have that very difficult conversation with the client. And as a result of him being incapable of having a hard conversation with his client and having the conversation of saying, look, if you go to trial in this case, you face the possibility of 6 decades in prison. The client really had no idea how to make a decision about whether or not he should in fact go to trial. He had a plea offer on the table that would have sent him to prison for 3 or 4 years. And as a result of the lawyer being unwilling to have a very difficult conversation with him, the client's now dealing with 20 years in prison, 4 or 5 times as much as he would have gotten on the pretrial offer. That's really, really illustrative of why it is that you need to make sure that you're dealing with someone, dealing with a lawyer who understands how to handle serious cases. If you're dealing with someone who quite honestly just seems sort of silly and doesn't understand that you have to have real world conversations with clients about difficult decisions that they have to make, then you could very well end up in that situation in any given case. Even on less serious cases in jurisdictions that really sentence very heavily. Your lawyer needs to know what the sentencing habits are of the jurisdiction, and they need to be able to talk to you about those things and have candid and open conversations with you. There's this thing that's going around now with lawyers that say, I never plead clients guilty, let's just go to trial. All this sort of what I consider to be nonsense, because quite honestly, there needs to be cases that need to get worked out. There are clients with very, very difficult facts and that need to just hear from a lawyer that you don't have a defense or you have a very low likelihood of success on the case given the evidence in it. And we need to try to work out a sentence that is lesser than what you would receive at trial. That's real world advice that you need to receive in some cases if the evidence substantiates it. It doesn't mean that necessarily you throw in the towel and don't argue motions on a case and don't try to challenge the state's evidence at every opportunity. But whenever it comes down to it, you are the person who, if it comes to going to trial and rejecting all the potential plea offers in the case, you are the person that's going to have to deal with prison time, that you need to know that your lawyer understands the risks that are associated with it and that he's conveyed those to you. If a lawyer doesn't get that, then you need to go hire somebody else. Got any questions about any of this stuff? Or if you think I'm completely wrong and that every client should absolutely go forward and exercise their right to trial and face that possibility, feel free to comment below. My name is Ben Sessions. My phone number is 470-225-7710. Thank you.